Welcome to Environmental Law course, dear learner and viewer. In continuation to our discussion about the constitutional dimension of environment in India, we will be discussing today on human right dimensions of environment in India. We are in a very comfortable position as we have taken note of the environmental dimensions of the environment, especially in reference to the rights, fundamental rights, Article 21, Article 19, Article 14, vis-a-vis the Directive is for State Policy, Article 47 and Article 48A, with that of Article 51 AG. We have also taken note of the federal framework of the environmental protection in India, both from the centripetal tendencies and the centrifugal essential inputs in the environmental activism and environment protection and sustainable development. Having a series of lecture on the environment and the constitutional protection, environment and the constitutional protection, or the constitutional protection to environment and sustainable development. Now we are going to deal specifically that how in comparative constitution and constitutionalism and environmentalism, we have noted the fact that there are two kinds of countries in the world. The first country appears to be have provisions on environment protection, and the another kind of a country is where right to environment has been specifically safeguarded into the constitution. So both these constitutional law which we have discussed under the environment protection under comparative constitutionalism, then we have taken note of the constitution of the world, which is broadly categorized in two categories: the constitution which gives some importance to the protection of environment and sustainable development and right to health and right to environment. And then there are certain constitutions in the world which have specifically engrafted right to environment and human health. Now, from this direction, we see that in India falls into the first category, and the first category is under Article 48A of the directive principles of a state policy. The state is being under a duty to protect and improve the environment, including the forest and wildlife of the country. Whereas Article 51 AG talks about that every citizen shall be under a duty to protect and improve the environment. In the entire spectrum of the 42nd constitutional amendment, which we have discussed in details in previous lectures, then what we find in 1976, although that uh, the government, the parliament has introduced a constitutional amendment having Article 48A and Article 51 AG, but the desideratum of the right to environment is something which we have seen in two kinds of the environment in the world that was missing in the India. But how that desideratum has been, and how that void, how that gap has been filled by the judicial interpretation of right to environment under Article 21 of the Indian Constitution, and then how it has promoted a human right dimension of the environment protection in India. That is the crux, and that is the central inquiry of the today's lecture. With this, dear learner and viewer, we will be trying to see that how the Indian judiciary, right from 1978, and 1978 or 1976 is important because 1976 is a date of the 42nd constitutional amendment, and 1978 is the pronouncement of Maneka Gandhi case, which has almost metamorphosed the entire notion and concept of Article 21. So, Article 21, right from 1950, A.K. Gopalan, and Article 21 in the post Manka, that is to be studied when we are going to discuss the human right dimensions of environment, and that study appears to be very imperative. In that concern, in that context, what will be dealing it, that we will first and foremost try to have incorporate that what are the juridical concern in the spectrum of the human right protection or the human right dimension of environment in India, then we'll be taking a survey of the legislative precept in India under the Indian Constitution, and as well as the catena of the environmental statute which has been passed time to time to give effect the goals of environment protection and sustainable development. We will also try to see that beside the juridical concerns and cross current and undercurrents and juridical postulates which have been visited in the human right dimensions of environment in India, we have the constitution at one hand and the statutory law protecting the environment on the other hand, and then we will try to see that how the institutional mechanism have created in this country, be that environment protection authority, be that central pollution control board, be that a state pollution control board, be that the planning commission, be that the Niti Aayog, be that the national green tribunal, be that any kind of a court, or be that the entire institution of what we can say the interstate water dispute commission. And then we see the detail, the National Human Rights Commission also, that how the institutional mechanism with this the pollution control board, with human rights commission, and we try to see the all kinds of commissionerate which has been established under the Constitution of India to give effect the question of human right to environment and environment protection and sustainable development. We will be looking at beside juridical concerns and postulates and doctrines and legislative precept under the Indian Constitution and the statutory law and a catena of the institutions and the paraphernalia of the environmental administration to look at the question that how they are going to dispense human right dimensions of environment in India. And then we will categorize our discussion into four broad categories, that how that in the absence of what is called right to environment was not engrafted as a fundamental right in the Indian Constitution, but how the judiciary very meticulously, silently and dramatically and perpetually uh, try to chisel out the notion and concept of the human right to environment under the heading of right to ecological balance, how it has created within the parameters of Article 21 vis-a-vis Article 48A of the Indian Constitution, how it tried to give a kind of a jurisprudence which confers the series and the catena of the rights which permeates into the decent and qualitative environment, and how right to environmental safety is taken as a hallmark, as an essential for the human right to environment, and how health and environment have been synergized and dovetailed to see that not only the human right to environment can be established unless we have a human right to health, and how the question of the health and environment are also being intertwined to see that these four categories of the judicial doctrination which we will peruse it through the lens of the decisions of the Supreme Court and High Courts. Then we will also try to see that how human right dimension to environment in India is being promoted under the compliance of international enviro human rights standards, meaning thereby even if that the country is not having any kind of a law and we require environment protection, but we find some international law on the point, be that climate change, be that wetland, be that any kind of the environmental problem which have not been hitherto addressed either in the legislative precept or the institutional mechanism, then the juridical concerns happens to revisit those questions, and it has given rise to a kind of the case law on the point, which try to see that even if you don't have the law in the national level, the international environmental human rights standard must be complied with. Alongside, we will try to see that how in a series of cases of the Supreme Court and the High Courts in India, we have notice that there is not only the rise of human right to environment, but there is also the rise of environmental equity, which is obviously is a question that is more broader and broad based, because human right is excessively human in character. But when we talk of the environmental equity, then it takes the entire consideration of the biotic and abiotic entities on this earth, and how the question of environmental equity is also being answered by some of the very leading cases on the point. And in the last, we will try to see that how beyond anthropocentric approach of the environmental law, which happen to be myopic, which happen to be short-sighted, which happens to be having a limited sense, then how it tries to see that the Indian judiciary, while fostering the human right dimension to environment in India, have created something, a kind of a discourse which transgress from anthropocentric to trans-anthropocentric approach. And in the last, we will try to see, as I have just reflected upon the point, that the human right dimension of environment in India happens to be human-centric. Can the entire approach of the human right to environment is a very viable option, or there are certain potent also. We understand that it carries a lot of potential, but we should not be oblivious of the fact that it is bereft of, or it is not having any kind of a portent, any kind of a pitfalls, any kind of a limitations, any kind of a shortcomings, that we will also be going to discuss in this lecture. With this synoptic outline, dear learner, and we are we are going to see that what is the judicial, what we mean and we want to connote and denote about the juridical concern of the human right to environment. Then we see the Indian environmental jurisprudence, which have evolved through a constant and perpetual interaction between the international human right norm, and how the international human right norm has been merged with the ecological values, which has been merged with the constitutional right, and which has compelled the court to interpret in a very different perspective. And that interpretation goes beyond the pale and authority of the traditional legal framework, and try to address the human right as environmental right as a matter of human right. And it also try to see that how in human right and environmental justice both can go alongside. Then will be looking at India's environmental law as a whole, and then we will try to see at the Indian environmental law, meaning thereby on the same nomenclature, that what is the potential of the Environment Protection Act 1986, that in giving rise to a kind of a human right framework which try to establish interlinkages between environment, health, agriculture, and sustainable development. That kind of a framework will be derived from the Environment Protection Act 1986. Then we'll be looking at whether after the establishment or after the enactment of the Protection of Human Rights Act in 1993 and establishment of National Human Rights Commission in 1995, that how the National Human Rights Commission happens to be seized with the matter of the human right to environment and realization of human right in matters of health, in matters of iodine deficiency, in matters of displacement, in matters of arsenic pollution, in matters of limited resources, and how the human right, despite giving attention to the Universal Declaration of Human Rights 1948, to International Covenant on Civil and Political Rights, Social, Cultural, and Educational Rights of 1966, have moved beyond its term of reference and the mandate to incorporate environment as a matter of human right under various categories. We'll be also looking at that what happens to be the disabilities and dignities and social justice question, or the environmental justice question in matters of Narmada, in matters of Bargi Dam austerities, the question of displacement, the question of rehabilitation, question of resettlement, question of loss of livelihood, all these questions, how the Human Rights Commission have tried to interpret, how it tried to interpret the safe drinking water issue under Article 21, and how the NHRC tried to look at the question of the human health sanitation is in reference to the manual scavengers plight in this country, and then how the NHRC have made crucial steps towards integrating the human right and environmental right into India's broader justice of social justice and environmental justice. Then will we try to see that how judiciary time to time have through the vehicle of the public interest litigation, which after the Maneka Gandhi and Justice P.N. Bhagwati's activism and judicial activism have relaxed the locus standi, and the very criteria of locus standi relaxation has created and opened a gate to agitate upon by the series of rights, the catena of right, and expansive interpretation of Article 21. So that procedural gateway, which was earlier established under Article 32 and 226, once it has been relaxed, that how the public interest litigation as a bulwark, as a springboard, have created a kind of an atmosphere where right to clean water, sanitation, ecological balance, and empowerment, and the question of the pollution and hazardous substances, and even the poor hazard planning have been addressed by the judicial recognition, judicial indoctrination, judicial postulates, and then we will, for the paucity of the time and to be very succinct and brief, what the judiciary has indoctrinated, we have categorized under the four categories, and that four categories that we have pulled out the cases pertaining to that which deals with, which confers right to ecological balance in relation to forest, rivers, wildlife, and the fragile ecosystem. And then it tried to see that how the Indian judiciary doctrinated that how under Article 48A and Article 21 of the Indian Constitution to have the right to decent and qualitative environment, and then how right to life is in a broader encompass, try to include right to clean air, right to clean water, right to have proper sanitation, right to pollution-free environment, and how the slow and gradual environmental degradation are appearing to be the spoliation of the right to life. And then we will also see that the series and the cluster of the industries which are engaged in the hazardous pursuit, which are engaged in a environmentally deleterious pursuits, happens to create a havoc and create a fear psychosis among the people, that if the proper safeguards have not been taken place, and if something escapes out of that industry, then how the question of right to environmental safety is important after the ecological balance, and right to decent and qualitative environment, and right to environmental safety. And then lastly, we try to see that how the Indian judiciary have tried to integrate, synergize, and dovetail the question of health and environment, and linking environment protection to the question of the public health, and coming very heavily on the authorities, municipalities, to ensure a proper management and a pollution-free environment and a hygienic condition and a sanitary condition to preserve right to life and human dignity and personal liberty. With this kind of a concern, we will try to look at what has been said in the human right dimensions of the environment, or human right dimensions of the environment in India. We will slightly slip into some details that as what exactly we wanted to convey about the juridical concern, and how the juridical concern have addressed the issue of environment protection and sustainable development. The juridical concern which happens to center around about the north-south equity. That is something a very paramount question in the Indian concern, because and the entire political economy of the environmental law, on which the environmental law, environmental standards, environmental compliance is based upon. And then the judicial concern, the very conceptualization of the judicial concern is important once we understand that what is required in North, what is required in South, what is required in developed world, what is required in developing world and underdeveloped world. And we will also see that the laws which drive its sustenance and life breath is what kind of economy and what kind of a political economy India had, and how it has handed down the slew of reform of the environmental law. That has to be also scanned in a very proper manner. We must have a comparative legal regime and try to see the compare and contrast the comparative legal regime, and to see that how the Indian environment protection, how the Indian biological and cultural diversity demand some very fundamental reform of the environmental right or the human right at the national level. And with this, we try to see that what are the international human right and environmental law corpus which serves as a guide and as an anchor sheet, and from where we can have some kind of the grand norm in the Kelsinite terms that can evolve during the period of time in the Indian constitution, in the judicial interpretation, in the judicial teleological coding and decoding, how this grand norm, how this anchor sheet is to be converted into a kind of environmental justice, human right to environment, and it creates a kind of enviro-legal order where the Indian judiciary happens to develop, interpret, and expand the entire doctrinal parameters and limitations of Article 21, which has been handed on in A.K. Gopalan case, and how the subaltern environmental movement, after having the gateway which has been opened, and when the PIL was introduced, how the subaltern environmental movement, how the grassroots environmental movement in India, how the NGO community, how, how the enlightened citizenry in this country have taken recourse to public interest litigation as a mechanism to, to agitate upon the series of environmental right, series of human right, including right to environment, and then how it tries to transgress from the first generation, second generation, and third generations of human right to environment, human right in general, and environment right in particular, and try to broaden the entire canvas and the canopy of the justiciable entitlement as a matter of the environmental right, taking recourse from Article 48A, how long we can have we can shelter into non-justiciable aspect of Article 48A in particular, and directive principles of state policy in general, and then how the judiciary have taken advantage of the PIL reform and galvanizing effect by the subaltern environmental movement have thoroughly expanded by representative suit, by declarations, by injunctions, by class action, by appointment of amicus curiae, by having a court-sponsored agencies, and suo motu cognizance of a series of environmental problems under the broad jurisdiction of the PILs. Then the judicial concerns which we are going to understand in the human right discourse happens to be that how the enviro human right jurisprudence in India is progressing, despite we feel there is a scathing criticism about the vague content of the human right to environment. We are not sure that what exactly the human right to environment, which shrouds in some kind of an ambiguity, how that is being created with a very clear cut and unmistakable term, the kind of a jurisprudence which the Supreme Court and the High Court in India have handed down to address environmental issue, and with a high degree of precisions and clarity, the legal protection to environment in India have resulted into deepening of the ecological values by having protecting the indigenous community, the marginalized communities of the present and future generation. It has also taken root to civil and political rights. It has taken root to particularly the constitutional right to environment, and then it tried to see the right to environment and sustainable development beyond right to life, and try encapsulate right to livelihood, right to health, and lastly how the judicial concern, starting from the north-south equity, from the political economy, from the comparative legal regime, and the entire discourse of individual human rights at the international level, have taken note of the Fatima Castani report of 1994, which is a report uh, which is a kind of a report submitted to United Nations Commission on Minorities and minorities, and then it tries to see the question of human right to environment for the first time in India. As we have seen, we have right to development declaration in 1986, we have 1987 declaration of 22 principles uh, by the World Commission on Environment and Development Expert Group on Environmental Law. We have 27 Rio principles, and then all these principles, how these principles are going to be integrated to say that as we have Universal Declaration of Human Rights, can we have Universal Declaration of Environmental Right in 1948? This 1992 report of the Fatma Castani tried to address the question of integration of environmental right and environment protection. Thus, we see that the Indian judiciary has been very conscious of the fact that how it can very effectively try to hone out its judicial craftsmanship to incorporate the human right to environment in India and human right dimension to environment in India by its series of the decision, and then that judicial concern encompasses a variety of issues and cross-current discourse and diametrics, and then it tries to take advantage of the new wave of the public interest and the subaltern environmental approaches and movement in this country to shape human right dimension to environment protection. With this, we try to see that how the legislative precept which has underpinned under directive principles of state policy and fundamental duties, meaning thereby that the reference to the 42nd Constitutional Amendment 1976, which introduced Article 48A and 51AG, which talks about that the state shall endeavor to protect and improve the environment to safeguard the forest and wildlife of the country, whereas Article 51 AG, every citizen shall protect to improve the natural environment, including forest, lakes, rivers, and wildlife, and to have compassion to living creature. These constitutional directives reflect a duty-oriented jurisprudence. It does not spell in 1942nd Constitutional Amendment any kind of a right-based approach to environment, but it tries to have a duty-based kind of an constitutional jurisprudence pertaining to the environment, and then we try to see that how the legislative precept, which is underpinned in the directive principle of state policy and fundamental duties, try to create a jurisprudential basis for the environmental law along with its intersection with the human right law, and then we try to see that how this directive principle of state policy and fundamental duties have great potentiality in giving effect that what it says, it is either technocentric or ecocentric or anthropocentric or transanthropocentric, but a careful reading and a combined reading of all these provisions of Article 48A and especially Article 51AG try to give this impression that every citizen shall be under a duty to protect and improve the natural environment, including forest and then lakes and rivers, wildlife. And the major question is to have compassion to living creature is a kind of a trans-anthropocentric jurisprudence. It's a kind of a jurisprudence known as anthropocentric. So what we see that Article 51 AG, which clearly spell out a duty-oriented jurisprudence, and in the first stage that the legal precept or legislative precept under the Constitution of India, under 42nd Constitutional Amendment in this country, then what we find is not tilted towards the right base, but to duty-based kind of a jurisprudence, and that duty-based jurisprudence is ethical, moral, compassionate, benevolence, kindness that has to be exhibited by the citizen and as well as the state under its doctrine of trusteeship and the entire natural resources in one sledgehammer manner, that is being that a state happens to be the custodian and the trustee of the natural resources, and they have to not commit any kind of a breach of trust. Then what we see that the legislative precept of Article 48A and 51AG, which give rise to an anthropocentric and trans anthropocentric approaches or ecocentric approaches, and it tries to repudiate the technocentric approaches in its constitutional perception, and thereby it's also important that beside the cardinal value which is attached to Article 48A as directive principles of a state policy, then we try to see there are other articles which also creates some kind of a relationship, and then what we feel that the entire vision and discourse of the environmental rights in India, human right dimension of environment in India is something to be studied very carefully, and it's a novel addition to what we can say the comparative constitutional law which we have studied in the very beginning. At the world level, the Indian constitution serve at least a kind of a constitution which are to be read with great interest, and try to see that how the basic precepts of the environment vis-a-vis right to environment as a matter of the human right has been heavily seated into Indian constitution under a judicial concern as well as the legislative precept. With this, my dear learner and viewer, I thank and I wish you a happy learning.